My name's Seton Motley. I'm with Less Government. I'm going to let these people introduce themselves. I'll introduce them by name, and then we'll let them talk for about 3 minutes. Basically, we're here to discuss network neutrality, what's next for it. We've got the court case in early fall, I guess, we're guessing. We don't know. It's up to the D.C. Circuit itself. There's basically 4 things I want to look at, and of course it'll be shaped by what the answers are from of the respective panelists. And of course, as Phil pointed out, I am not an unbiased moderator. I'm actually in opposition to net neutrality. The answer is no. But what we want to look at is basically from 4 overarching principles. Is it's not so much it's the product which is a problem. Net neutrality is a problem, but it's the process at which we arrived at it, which is the FCC just unilaterally said we're going to impose net neutrality. We haven't had congressional authority to do so. We're just going to impose it. And that opens the door wide open to, okay, what else are they going to crown themselves kings of? For the Google fans out there, is search neutrality next? I mean, once you open that can of worms and let an agency become its own authoritator, its own diviner of what powers it has, it doesn't stop. So we need to look at it from that perspective. We have to look at it. While it's going to be a problem, it's an inside the Beltway fight right now. The consumers, we need to look at the impact on consumers. I would argue it's not going to be terrible instantaneously should this be upheld. We also need to look at, are there remedies that exist for net neutrality violations without net neutrality regulations? The FTC, non-compete problems. I'll ask Phil about that in a moment. But basically, do we have solutions that exist without imposing this whole new swath of regulations? And 4, and this is the kumbaya moment, we had the International Telecommunications Union looking to regulate the internet, and everybody at this table was opposed to them doing that. And we should thank Gigi, who likes net neutrality, and Sasha, who likes net neutrality, for coming together with everyone else and saying that the UN, the ITU, should not be regulating the internet internationally. My question would be, does it look a little schizophrenic when we're pushing for internet regulations domestically to then go abroad and say, oh, you don't do it, we'll do it. So with that in mind, I want each person to introduce themselves and just give their 3-minute intro on where they are on net neutrality, the regulation, and what they see going forward. We'll start with, we like girls best, so we'll start with Gigi Sohn from Public Knowledge.
Well, good morning, everybody. It's great to be here, and I love working with Seton. We agree on almost nothing, but we still break bread
we
together.
both agree the Mets stink, right?
They're 5-2, but they always have a good April.
Like
Mets fans are always very happy in April, and then very sad when July and August roll around. So
you're better than the Yankees.
Right now, I'm proud to wear my Met hat. I will not be proud in about 2 months.
Well, you're better than the Yankees.
I think John Buck's going to be the MVP.
Okay.
So I want to make 2 opening points, and then, since you have already put some things on the table, respond to several of the things that you just said, Seton. The case that's going to be heard in front of the D.C. Circuit whenever, it's interesting, the case has already been briefed. This is the challenge to the FCC's open internet rules, and Verizon and Metro PCS, although it's now part of T-Mobile, which is kind of an interesting question whether they're going to continue challenging the rules. I'm going to talk to T-Mobile about that. Challenge the rules as beyond the FCC's authority, saying that they do not have the power under the Communications Act to adopt these rules. Case has been briefed, but it's not been set for oral argument. So we have no idea. It may be fall at the earliest before we have a ruling. So this thing has dragged on really a very, very long time, which leads me to my first point, is that the open internet rules have been in place for about 18 months now. It actually took the FCC almost a year to actually get them to be operative. It wasn't so much the FCC's fault as the Office of Management and Budget, which has to review rules. And the world has not fallen apart. And I think that's really important. I think the companies, most of the companies, and certainly the trade associations, were fine with the FCC's rules. Of course, Sasha and I think they're kind of weak. But to the extent that the challenge is to the rules as they stand today, the National Cable Telecommunications Association supported it, and the other cable companies have supported it. AT&T supports it. And the only folks that haven't supported it are Verizon and Metro PCS. So the world is not falling apart. The industry thinks they're fine. So my question is, what's the big problem? I mean, we can talk about principle, but on a practical level, there's, the rules are working and they're working fine. That's number one. Number two, the second point I want to make is, I think it's too narrow to look at this case as just about open internet / net neutrality. Okay, this case is about the FCC's ability to do anything when it comes to broadband, take any kind of action, including protect public safety, protect children's privacy, ensure that everybody has access to broadband, ensure consumer protection. So if you get some ridiculous bill, some third-party charges, and it appears on your broadband bill, want the free market to take care of that, or do you think maybe government might have a role in setting some rules to make sure that you don't get completely and totally ripped off by, third-party trolls? So I think it's really important. Everybody wants to focus on net neutrality because that's controversial, but this case is about so much more than that. It's about whether the FCC is going to have any relevance at all when it comes to the communication system of the 21st century. There are maybe people at this table that think the FCC should just shrivel up and go away. I don't think that's the popular sentiment. I think people do want some cop on the beat. And the FCC, however imperfect, and I actually agree with you with some of the process questions you raised, really has to have some role, in my opinion anyway. So let me just very quickly address 2 points. You talked about how the FCC unilaterally and without authority adopted these rules. Look, agencies interpret their authority all the time, okay? And then it's courts, when they get challenged, it's for courts to decide whether they've overstepped that authority. So what the FCC has done here is what every other agency does. It did what it thought it was right. It adopted rules that it thought protected competition and consumer protection. And some companies and some public interest groups think they overstepped their bounds and that they don't have the authority to do this under the Communications Act, and the court will decide. How the court will decide, I think it's very interesting. We can talk about that in the question and answer. My last point is about the ITU. And yes, public knowledge was very involved. We sent 2 lawyers, we're on the U.S. delegation. But the fight over whether this sort of international centralized body should have control over the internet is not the same as the net neutrality battle. What the ITU battle was about was to ensure that countries have the sovereignty, have the ability to regulate their communication systems as they see fit. I mean, first of all, in the first instance, I do not believe open internet is about regulating the internet. It's about regulating the on-ramps to the internet, the telecommunications byways, which have been regulated for 100 years. Okay, so that's the first disagreement. But the second disagreement is really fundamentally about what the ITU battle was about. We do not believe that the ITU, where Ghana gets the same vote as the United States, should be able to tell the United States or Canada or anybody else how to regulate their communication systems. So I do think that the debate over the ITU has been misconstrued. And it's really about individual countries having the ability to regulate their communication systems as they see fit. Now, I will agree, that in the case of Russia and some of the Arab countries, we don't like what they want to do. They want to, block traffic. But you know what? I hate to say, that's kind of their right. And we don't want them telling us what to do, and I don't think they want us telling them what to do.
Well, I'd like to thank Gigi for making the argument to close both the FCC and the UN. That's fantastic. I'm not going to... up next is Phil Kerpen from American Commitment. I'm not going to judge the opening statements. I'm going to be just let the lawyers say what they want. Well, no, I was complimenting you on closing 2 completely useless entities.
Yeah, I would agree that this is actually a fight about something much bigger than the instant rulemaking that we're talking about. And I would look to the description from kind of the original godfather of the net neutrality movement to describe what this is really about, and that would be the founder of Free Press, Robert McChesney. Free Press leads the Save the Internet Coalition that all of the advocates of net neutrality are part of. And he said in an interview, it was with a socialist website, so I think he let his guard down a little bit more than he typically would. He said, at the moment, the battle over network neutrality is not to completely eliminate the telephone and cable companies. We are not at that point yet. But the ultimate goal is to get rid of the media capitalists and the phone and cable companies and to divest them from control. And I think you have to understand all of this debate in the context that the left-wing advocates, the principal advocates for regulation, are not only unconcerned about the potential to undermine the incentive for private investment, some of them actively welcome that because they would prefer to see taxpayer dollars used and they would prefer to see government-owned and controlled networks. And I think that is the exact opposite of what has worked for us so successfully, and that should not be the goal. I mean, you look at the infrastructure in this country, you've got crumbling road infrastructure, you've got crumbling water infrastructure, you've got a pretty sorry state of the electric grid. The one infrastructure system that works extraordinarily well is broadband because it's the one that's been driven by private investment and competition. And so this idea, this mentality that broadband should look more like a regulated utility or even a municipal or federally owned utility and less like the private competitive market it's been, I think moves in the exactly wrong direction. And moreover, even if you take that view, the money's not there for federal investment. There's no money. I just waited in a long line outside this building because of sequestration. The appropriators have no money. And so if we want innovation to continue, if we want investment to continue, we need to get the incentives right for private investment to continue. It's the only game in town in that respect. And I think the fact that we haven't seen a catastrophic collapse in investment based on this rule kind of misses the point. First of all, it's impossible to know what innovation might have happened but didn't, what market arrangements might have happened. When you forbid certain market arrangements from arising, you'll never know whether they were economically efficient or not, and so you kind of don't get to know the path not taken. But also, this is the first step, I think, towards more severe and more heavy-handed regulation if it's allowed to continue, especially from that process standpoint. The FCC was acting in direct defiance of the court's decision in Comcast versus FCC. It was clear they didn't have jurisdiction in this instance, and they said, well, we think we can get the major stakeholders on board, and they had all these secret meetings, closed-door meetings. They thought they had everyone on board. As it turned out, they were one or two players short of that unanimity to prevent anyone from challenging it, but they basically thought, we can get this done in a back room, no one will challenge it, and it won't matter that we're acting where we don't have jurisdiction. And I think that is indeed a very frightening precedent. Seton asked for 3 minutes, so I'll keep this brief, but I do want to address the international issue because I think that there's a clear connection between the credibility of our diplomatic efforts abroad to stop countries from adopting very repressive policies toward content restriction and our own willingness to regulate the internet domestically in the name of net neutrality. And I'll point out that one of Verizon's arguments is a First Amendment argument. This is independent of the jurisdiction argument. Like an editor of a newspaper, they argue, they should not be compelled to carry content that they may disagree with, or they may have a business interest in not carrying on the same terms as other content. And so there's a First Amendment issue here. I think that in particular bears on other countries saying that that the government and not private companies will be the arbiters of what content is or is not carried. And I would point out that Phil Verveer, no conservative by any means, but one of the top diplomats in the State Department dealing with repression on the internet in other countries abroad, was quoted as saying, "I can tell you from my travels around the world and my discussions with figures in various governments around the world, there is a very significant preoccupation with respect to what we are proposing with respect to broadband and especially with respect to net neutrality." They are seizing on this. I also think it may not have been a coincidence that just weeks after the FCC finalized this order, Hugo Chavez in Venezuela cracked down on website content and cited U.S. regulation as one of the reasons that this was an acceptable thing to do. And so we are not operating in a vacuum. Even if our regulations are well-intentioned, it will undermine the legitimacy of our diplomatic efforts to prevent more aggressive content-based regulation abroad. And I would dispute the idea that we're just talking about on-ramps and that the internet is something different from that. The internet is a network of networks. Innovation takes place in the individual networks. It always has. And I would quote Robert Kahn on this point, one of the key engineers in the development of the internet, who said, "I am totally opposed to mandating that nothing interesting can happen inside the network." And I'll close with that.
Yeah, I asked for 3-minute intros to try to keep people to 8. Up next is Sasha Meinroth from the New America Foundation as we swing back left.
So in 2006, I wrote a paper called The New Network Neutrality Criteria for Internet Freedom. And the notion behind that is certainly that we can, left and right, both agree that there is a role to be played to protect free speech, to prevent censorship, to protect our privacy, that these are roles that should be taken by government to ensure that a people is free in those regards. And unfortunately, network neutrality is rapidly ascending into the space of censorship, of curtailing our rights, of creating spaces where we do not have the ability to express ourselves. The internet has always been a best effort network. It's predicated, the basic functioning, the protocols that run the internet are based on this being a best effort network. And until relatively recently, that's exactly how the internet did, in fact, work. Before I came to DC, I worked for the Cooperative Association of Internet Data Analysis at the San Diego Supercomputing Center. Coming to DC, I founded Measurement Lab, which is now the world's largest broadband measurement platform. I come out of the research and scientific arena, and I continue to do empirically backed research and analysis. We've got 700 terabytes of data on what's happening online that we give away for free to anyone that wants to do their own analysis. Network neutrality has incredible benefits. The abrogation of network neutrality has tremendous costs to consumers. So today it's normative that you have bundling of services, right? Voice, cable, and internet get bundled together, and it's very difficult to disaggregate those things. Tomorrow, what you're going to see is bundling within services. You want internet? Well, you're going to have to pay extra for a variety of different add-ons, and you, the consumer, will have no choice about whether to accept that or not. We did a study of 22 cities around the globe to see what the current cost to consumers is. And I'll run through a couple of quick numbers just to drive home how crazy expensive this can be. So right now, today, for worse services in the United States, on average, we pay about $20 more per month. There's over 100 million lines in the United States. That's $2 billion in extra payments a year over the next 10 years, which is what we always talk about in terms of national budgeting, et cetera. You're talking about $250 billion in overpayments taken out of your pocketbooks, more than what other people around the globe are paying. So I see network neutrality and internet freedom as two facets of a process that's beginning to infringe upon our free speech rights. It's a process that's beginning to censor online content here in the United States. We've had numerous occasions where that's happened, from AT&T and Comcast and others. And it's also a pocketbook issue. So I'll close with that.
I'll bite my tongue and say, Ryan Radia from Competitive Enterprise Institute, you're 3 to 8 minutes.
Thanks, Seton, and thanks for inviting me. Net neutrality, the best effort principle, may be how the internet works today, at least to a significant extent, but that doesn't mean that it's the way the internet should always work. We often hear people complaining about the fact that services are unbundled. People hate paying baggage fees on airlines. They hate paying extra for more legroom. Now when it comes to net neutrality, some people would rather that it, in fact, be unbundled. These are not questions that, to me, Washington is well-equipped to answer. These are decisions that are best made at a market in which companies are vying for consumers and consumers are making choices. Like Gigi and Phil, I agree that this is, in fact, about much more than net neutrality. It's about whether there will exist a limiting principle that curtails the role that the FCC can play in regulating the behavior of internet providers and companies that are engaged in the business, in businesses that are tangential to providing internet service. Now, there may be some instances where the FCC can do good in the context of billing disputes, for instance. The question is whether an industry-specific regulator, one that was created in an era where we had a regulated monopoly, is best equipped to handle these sorts of disputes, and whether there exists under current law a sufficient limitation on what the FCC can do in this space. For all of the good things that the agency can do, and it certainly has on many occasions, it has done or tried to do things that are much more harmful. For instance, the FCC has been playing an increasingly active role in regulating app stores. In 2009, the FCC sent a letter to Apple about its rejection of Google Voice. More recently, we saw the dispute over FaceTime and the Apple App Store again. The FCC has been studying data caps for quite some time. If the DC Circuit upholds the net neutrality rule, the open internet order, where is the limiting principle? To what extent is the FCC limited from essentially acting as if it is a broad regulator of anything that has to do with provision of internet service? I see that as very destructive because it goes well beyond the limited and legitimate consumer protection principles. So the alternative is, what do we have instead? I agree with Gigi, we need a cop on the beat. So the question is, what should that cop on the beat look like? Should there be multiple cops? First of all, that cop need not be government. Many industries are policed, not just through companies voluntarily engaging in good conduct, although there certainly are no shortage of instances of reputational forces eliciting good conduct. There are also institutions, most notably BITEG, the Broadband Internet Technical Advisory Group, which can act to resolve disputes over net neutrality in a multi-stakeholder situation. The content companies are not small, they're not weak. The Googles, the Netflixes, the Amazons, and so forth, they can sit in a room with large ISPs and hammer out agreements that can balance the various interests across the markets on the internet in a way that to me is a far more flexible approach that involves fewer legal costs. It allows for the disputes to be resolved in a way that is flexible, that can adapt in a way that governmental institutions can't. There is, of course, also the antitrust laws. Now, I may have objections to those laws and the way they're applied, but the fact is that no one disputes that Section 2 of the Sherman Act empowers the Justice Department to act against internet service providers that engage in monopolization, where they are acting in a way that is anti-competitive. If an ISP were to stop dealing with a content provider that it is currently dealing with profitably in a way that threatens to foreclose an auxiliary market, that authority already exists. The government can already act to police that conduct. It's not an issue that in any way merits the involvement of the FCC. And of course, well-established laws prohibiting consumer fraud, both state laws and federal laws, allow for a wide array of entities from class action lawyers to state attorneys general, possibly even the Federal Trade Commission. While it is not allowed to regulate common carriers, it is my view that the internet service providers are not common carriers. That's the FCC's view as well under current law. So the question is not whether there should be a cop on the beat, and the question is whether there should be a cop on the beat whose authority is limited to the scope of enforcement of powers that is necessary to actually protect consumers, to stop providers from engaging in practices that are deceptive, which includes billing-related issues. The virtue of this approach, of a more narrow approach, is that first it reflects the fact that this is a competitive market. This is in fact a market, the market for internet service, that is less concentrated than many other markets, like internet search, for instance. Yet, across many markets, we don't have industry-specific regulators with essentially unchecked power to do whatever they think is in the public interest, which is essentially a meaningless standard. Rather, we have narrow, well-defined authority based on the principle that consumers need protection from harmful practices. That, to me, is the way that we address net neutrality disputes to the extent that they arise. I'm not sure if they will arise, but we certainly don't know what sort of business models we'd have today were it not for the last 18 months of net neutrality. Would we have fewer data caps and instead have alternative means of internet service providers pricing their services? That may well be the case. Pricing a declining marginal cost industry, a network industry, is a very complex business in a way that it can make that network sustainable and in a way that can ultimately serve consumers. We haven't answered those questions yet, and I don't think we're going to if we don't curtail the FCC's authority to act in this area, which is something that the court will hopefully do, and if not, Congress ought to do.
Excellent, thank you. Okay, we're going to do questions from me to the panel for a bit, and then we're going to go to questions from the audience to pretty much round this out. So I'd like to start with Gigi again. What is it that you find lacking about the pre-net neutrality model, where on a case-by-case basis, when a situation arose, you use the existing law with the FTC, the Federal Trade Commission, as the lead cop on the beat, that you found to be lacking? And I want to follow up on something you said in your opening statement. You almost seem to say, and I don't think you meant this, so I'm actually going to ask you this as a favor to help you clarify, like the FCC should grab this authority without congressional approval to justify its existence. And what was wrong with the pre-existing model of case-by-case analysis, FTC-led harm reparations, versus now having the FCC preemptively traffic the beat?
Okay, so name me one time that the FTC ever looked at a carriage dispute with regard to broadband. They never have, and even though we've tried, because the FCC's been so weak, to go to them and ask them to do that, they haven't done it either. It's because they don't think they have the authority. Look, the antitrust laws, I'm not an antitrust expert, but I know enough to know that they're very weak, okay? And they're very narrow. They get to unfair and deceptive trade practices, which don't necessarily cover some of the favoritism that we're concerned about. And the other thing that kind of makes me chuckle, although I will give Ryan credit for being honest, on the one hand, libertarians, the right, talk about, well, go to the FTC, use the antitrust laws, and then, AT&T proposes to buy T-Mobile, and all of a sudden everybody's, in a big lather about how could you say that a merger like that can be blocked. So the antitrust laws have teeth, or don't they? Okay, I don't think the FTC itself thinks that the laws have enough teeth to be concerned with what we're concerned about. And what we are concerned about, and I think Sasha said it really, really well, is that those that control access to the internet will play favorites with traffic because of money or any other reason, okay? We like the end-to-end principle. Who likes their cable? Who likes the fact that their cable operator gets to determine what channels are on their system and where they are on their system and who's on what tier? Nobody likes that. Everybody would like to be able to pick and choose. Well, that's what the internet... Phil, let me finish, okay? Well, that's what the internet is all about, all right? And we want to keep it that way. So we think there should be a backstop, and we think these rules, even though we'd like to see them a little stronger, are that backstop. But the shell game around antitrust I find very, very curious, and I'd like to hear you guys say if the FTC has ever intervened in a broadband dispute of this kind, and what authority they would use in order to solve something like that. Let me address just a few more things. I'm the co-chair of the BTAG, so I know a little bit how it works, and I like it a lot, okay? But the BTAG does not resolve disputes. What it does is it looks at network management practices to see if they are reasonable. Now, the exception to the net neutrality rules to favoritism by a broadband provider is if they are engaging in reasonable network management. Right? But if there's going to be a fight between, let's say, a Netflix and a Comcast, or an AT&T and an Apple, BTAG is not going to resolve that, okay? I like the multi-stakeholder model for a lot of things, particularly technical things. But when it comes to situations where there are winners and losers, you need to have a government backup of some sort. So that's number one. Number two, you asked me a second question and I forgot it because I just gave a big speech. But, so ask it to me again.
The question is, and I think I've forgotten it too, is...
Oh, the authority question,
The authority question.
Okay.
To justify the FCC's existence.
I don't think that the FCC's authority in this case is very strong. Okay, I've been pretty public about that, even though we're defending their authority in court, all right? We thought that they should do the smart thing, the thing that was most legally supportable, and say that Internet access service is a telecommunications service under Title II of the Communications Act. That would have given them the most solid footing. I can't say hands down they would have won, but certainly Justice Scalia in his dissent in the Brand X case in 2005, thought that that was the smarter course, all right? So I don't think what the FCC did here was smart, okay? And I think they are stretching the bounds of their authority. And I will remind everybody in this audience that my organization paid a buttload of money to Steptoe and Johnson to challenge the FCC's authority when it adopted the broadcast flag, okay, which was basically a digital rights mandate that basically required every single digital television set and every device downstream from a digital television set to read and obey digital rights management in a broadcast signal. We won, but my organization was significantly poorer for it. So we do not believe, and Robert McChesney is not on my board, and we frequently disagree with Free Press, even though we frequently agree with them. Okay? We do not think the FCC's authority should be unbounded. We do not think that broadband should be a regulated utility. That is a red herring. Okay? The question in front of us is that should there be an agency that protects consumers, protects competition when it comes to the most, vibrant communication system? And yeah, I know Verizon made a First Amendment argument. I think it will fail. This is not a content-based regulation, number one. And number two, as the Supreme Court has said many times in the Turner case and other cases, the public has rights too. All right? Telephone companies, cable companies use public rights of way. Wireless companies use the public spectrum, and whether you like it or not, it is still licensed by the government. It's still owned by the public. Right? That makes the First Amendment equation very, very different than in a situation of a newspaper or a situation or other situations that implicate the First Amendment. So I'll stop there.
I don't know how much a buttload of money is, but it sounds like a lot. Phil.
Depends on the size of your butt.
Yes. She's touched on, and I want to explore with you, she repeatedly says someone needs to be on the beat. And she wants the FCC to be on the beat with these net neutrality rules. But again, Congress hasn't granted them written a law that says, hey, FCC, you're the cop on the beat on this. You pointed to a, for lack of a better term, a slippery slope argument with regard to it starts here, but it doesn't end here. I just want you to expound on your concerns of A, the FCC grabbing authority over something it doesn't have congressional authority to, and B, where you think that ends up as far as the internet, not just net neutrality, but the internet. And I'd like you to address her Gigi's. It was not an insult. Gigi's concept of that they should have gone Title II and reclassified the internet as a common carrier.
Yeah, I think it's interesting that just moments before we were told that the public utility model is a red herring, we were told that the internet should be reclassified under a public utility model under Title II of the Telecom Act, which would treat the internet as the old-fashioned phone system, with every aspect of the network operation being subject to prior approval by the FCC, with a mother may I type regime that I think is extraordinarily ill-suited to the modern marketplace. Craig Moffett, no ideologue, but one of the top Wall Street analysts of the sector, referred to that as the nuclear option because of the massive negative impact that it would have on investment and on innovation. So I think that the FCC was very wise not to go down that path. I hope that they don't react to a court defeat by going with a nuclear escalation with an even more extreme regulatory measure. And I don't see this great need for a cop on the beat. I think the competitive marketplace has done an extraordinarily good job at disciplining behaviors. I think that the reality has largely passed this political debate by. A few years ago, the example that everyone used for why we needed regulation is otherwise the carriers would block Netflix. Netflix now has compelling content, and they've got enough clout in the marketplace that they're getting carriers to put their CDN servers in their data centers without paying, because they say, your customers want this. And so we've seen this tremendous innovation and kind of competitive marketplace that I think is serving consumers extraordinarily well. And I really fear that if we supplant that with a top-down government regulatory model, where we say every aspect of the network is going to essentially be determined by regulators, we may get much worse outcomes. And moreover, without competition, when government makes errors in its management and control of that network, there will be no place for consumers to turn. We'll basically just have a single system.
Sasha, I saw you scribbling. I'm just going to throw it to you and say you'd like to respond to Phil to what he just said.
Gosh. On the one hand, I think you have sort of a rhetoric of hyperbole and fear, right? The nuclear option. You've got red baiting in here with people being called socialists. Me, I'm driven by science, I'm driven by research, I'm driven by data, and I'm driven by empirical outcomes. What convinces me and what I would welcome would be show me the data, show me what's going on. Because right now, when we're doing research on the costs and the penetration rates of broadband and the outcomes in the United States, two things. One is we're the only highly industrialized nation asking the question of whether our communications industry has purview over the internet. And number two is in a single decade, we've gone from number one across the board to a country that's middling, that has higher costs of broadband connectivity in fewer locations in the United States, worse service than a growing list of other countries. And this is across not one or two or three different metrics. This is across a host of different metrics over multi-year period. So either you believe there's a global conspiracy of researchers and scientists and business and governments and everyone working to present wrong data, or you have to look at the overwhelming evidence of the outcomes of this kind of debate and think about the detriments that it has on our economy and our global competitiveness. So to me, the choice is clear. Until somebody else wants to show up with 700 terabytes of data and say, here's something else, the rhetoric, to me, is not nearly as compelling as the data.
It's because the globe would never conspire to posit a fallacy, ClimateGate. Ryan, do you have any data that contramands what Mr. Meinrath just offered and his perspective on how middling the United States is when it comes to broadband capacity and service?
First, I would point to what is in many respects the least regulated sector of America's broadband market, which is the wireless market. In that realm, America is undisputedly the leader in that no other country has multiple providers offering what is, for the most part, if you look at population, nationwide LTE coverage. When it comes to the level of competition in wireless and the level of speed, we see wireless as, in the United States, a success. Now, in wireline, we are not doing nearly as poorly, depending on which data set you look at, but in fact, it's a fallacy to assume that just because we don't have the fastest internet, that is inherently a problem. Google recently unveiled its gigabit fiber service in Kansas City, and a great article by Farhad Manjoo on Slate points out that nobody actually knows how to use gigabit. So we could throw $100 billion, $1 trillion at building better broadband. Would it actually deliver positive economic outcomes on net when you adjust for the resources that could have gone towards alternative purposes? It's entirely unclear. If we want the wireline broadband market to grow and thrive, the opposite approach, the wrong approach, is the Title II. Even if this involves the FCC reclassifying and then forbearing from engaging in particularly egregious regulations, price caps, and so forth, you're not going to have a regime where wireline providers are willing to invest. What we should be seeing is companies like Verizon rolling out Fios in more markets. Yet we've seen one of the biggest barriers to that being municipalities who have onerous franchising requirements again, in the name of the public interest. When government says you have to offer X, Y, and Z service commitments, that inhibits the growth of wireline broadband. It does not stimulate it. Similarly, we see other companies who are making major investments. Comcast, for instance, offers recently increased the speed of its of a standard midline tier to 25 megabits, and in fact, this is I believe the 6th time that Comcast has substantially increased the throughput of its broadband offering in the last 10 years without increasing the price in nominal terms. So in real terms, it's actually slightly gone down on the broadband side. So the solution to our broadband woes, to the extent that they do exist, which they generally don't, is one in which government does not go down the path of net neutrality regulation. And just because Gigi brought up the First Amendment angle, which I find fascinating, my organization CEI, along with Tech Freedom and the Free State Foundation and the Cato Institute, filed a brief supporting the claim that there is a First Amendment right, and there are, I think, two important distinctions that distinguish this from Turner. First, there is no congressional statement that there is an overwhelming, compelling governmental interest in net neutrality. This is something that the FCC has concocted on its own, unlike the must-carry standard in Turner. And second, remember that the net neutrality rule is not content neutral. If it were, it would prohibit all discrimination. In fact, it allows for reasonable network management, meaning the FCC will say, well, it's okay to block spam, or it's okay to block this type of content or discriminate against it, but not this other type. That, to me, is the hallmark of content-based regulation. It's saying, well, based on what the content of the packet is, we'll decide whether you can discriminate against it or not. So there is a compelling First Amendment case to be made that these providers, though they may not have exercised it on many occasions, can make these choices. The First Amendment does not say that no company shall block. It says Congress shall make no law, and of course that applies to all governmental agencies. But it is the role of government to allow private property owners to make decisions about what speech to allow. Just because I'm not the speaker doesn't mean that I don't have a right to control the speech that occurs on the private property that I own, and that's an activity that the FCC's rule would forbid in many cases.
And since Gigi was getting whiplash during the First Amendment portion of the program, I'd like to give you the opportunity to, since you filed in that regard, would you like to flesh out what your filing is and why you think it's a bad argument for the First Amendment argument?
Brian keeps talking about private property, and that's the fallacy right then and there. I mean, that's the flaw in your argument. I mean, we can discuss whether, it's a content-based regulation or not, but AT&T and Verizon do not own the distribution system, okay? They do not own the spectrum through which they provide services.
Can I ask a quick question?
Yeah.
Since Comcast built the pipes, do they own it?
Well, they don't own the roads that it's buried under. Their pipes wouldn't be worth jack squat if municipalities didn't give them the right to dig up the roads, okay? Or if poles weren't available. I mean, there's government, like it or not, government is threaded through this whole thing, and the American public is threaded through this whole thing. Again, it's not like a book that you just print. There are rights of ways that are being used that are owned by the public and localities. There's public spectrum that's used. So that's when you can talk about private property till the cows come home, but the jurisprudence isn't there, and the reality isn't there. We're using public property in every single one of these situations. Two other points I want to make is, see, this is what I don't understand. Is the broadband industry thriving under net neutrality? Or is it just, not investing and it's all horrible? Because I'm hearing both things from folks on the other side. Some ISPs, including Comcast, have 90% profit margins. You want more data, Sasha? There's more data. Look at the profit margins of internet service providers. They are thriving. They are minting money, buttloads of money, if I could say it again, okay? That's another, I think, really, really important data point. And then you said something, and we also need to talk about competition, because Phil threw out competition. Oh, there's tons of competition out there, okay? Has anybody been to Silicon Valley or Northern California lately? When it comes to a wireline service, they don't have any competition. They got a choice of one, and it's called Comcast. If you go to most places, okay, most places that are in huge cities, like New York or Washington, I mean, I don't even have that much choice. I've got a choice of 3, and I consider myself lucky. Most people have a choice of 2 wireline providers if they're lucky. So is it a monopoly? No. But should we not care because it's a duopoly? I think we ought to care. And, maybe one day wireless will be a substitute, but it sure as heck isn't now. All right? And unfortunately, poor kids have to sit outside McDonald's and use their Wi-Fi to do their homework at night, okay, because they can't get the wireline, they can't afford the wireline access to have a computer and work in their homes. And I think that's a really, really unfortunate case. I just have to ask you a clarification on one thing, Ryan, if you don't mind me taking the moderator's prerogative. You said something about municipal broadband and I don't understand what you're talking about, because what I'm seeing happen is, to the extent that municipalities want to build their own broadband systems, the incumbents come in and try to squash them like a bug. I mean, right now, several states are trying to pass laws to prohibit municipal broadband. And a whole bunch of them already have, like half the country has already passed laws that will prohibit a municipality from building their own system to compete. You know what freaks out an incumbent? It's when a Google Fiber comes and builds in Kansas City. I mean, Time Warner Cable is having an aneurysm. That's what drives down prices. That's what drives up speeds. And this nonsense is, we have enough broadband, and who could use a gigabit? Believe you me, people will find a way to use a gigabit. And if that's the broadband industry's best argument, is that we have good enough broadband and we don't need a gig, wow, it's like, please use less of my service. I want you to use less. I'm not a business person, but that doesn't seem to me to be a very good strategy.
Well, you're clearly not a business person. I'm just kidding.
She took it as a compliment.
Yeah, I know. Behind enemy lines. She's talking, she cited you by name as far as competition is concerned. And I do have a data point, if I may play non-moderator for a second, since I seated you the moderator table. I think wired broadband subscriptions have gone up 7% in the last 2 years, and wireless has gone up 286%. So while you may not view wireless as competition to wired, it seems like the consumers do. So,
How does that data point prove that? I don't understand.
because they're signing up for it in dramatic numbers, which means
You
they...
just said wireline went up 28.
No, wireless.
Okay.
It went up 286%.
Doesn't mean it's a substitute, it's a compliment. That's your answer.
So, as far as the competition is concerned, as far as taxing competitors to then fund a competitor, taxing ISPs to then fund competitors to ISPs, how do you view that from a fairness perspective, because we all love fairness, and how do you view it from a actual execution perspective? How are municipalities and governments going to do when they enter the broadband business?
Well, first I would point out that we rank third in the world according to the OECD in intermodal competition. So and Sasha loves using international rankings when they advance his argument. I think that it's very interesting that ranking is not more focused on, because say we should be more like these other countries who rank better in broadband speeds and availability and so on, mostly for demographic reasons. They're mostly denser, more urban countries. If you look kind of apples to apples at densely populated U.S. states, we tend to perform very well in those rankings. But the solutions of more government control, government-owned networks, government investment, and so on, really doesn't really ignores the fact that we're already performing very, very well in terms of the number of choices that are available in intermodal competition. And you look at Sasha's own study, if you look at the places that have government networks, the prices were not lower than the private networks. In Chattanooga, he's got the triple play at $129.51 a month. In Lafayette, $103.89. They're not world-beating in terms of their pricing. They might be competitive. I think they're actually a little more than some of their competitors in those cities. And again, the international comparison, George Ford did an excellent post on this. They ignores huge quality differences across countries. For instance, the Riga, Latvia package includes a phone service that has an additional 37 cents per minute charge if you actually make any phone calls. So that price of $25, that could go up very, very quickly if you ever actually use the phone. It also included only 60 television channels compared to hundreds in most of the U.S. offerings. If you just look at the content costs for Comcast, they're paying $30 a subscriber to the content companies. You're never going to get a $25 triple play. I don't think you can look at gross margins as a meaningful measure of return on investment in a network industry with high fixed and sunk costs. So they're always going to look very high. You need to have a return on capital to justify the CapEx in the first place and to continue to have innovation and investment in these enormous multi-billion-dollar networks. And so I don't think that's the right metric, and I think we're actually performing very well. If you get out ahead of the business case, if you build out a network that customers aren't going to be there for, on the hopes that they'll figure out something to do with it, you're going to end up in bankruptcy pretty quickly. I mean, these are enormous decisions that need to be made on a demonstrated business case. I mean, you've got to have the return on capital to be able to raise the money and to be able to justify it to investors, and that's not there. And the best data point we have, when we talk about empirical data, the best data point we have is from the 700 megahertz auction, where the C block sold for 72% less than the B block. I mean, there is an enormous difference in the market value of encumbered and unencumbered spectrum with respect to net neutrality regulations, and we should take that as the best evidence that there is an enormous economic cost associated with this. That is the clearest and most relevant on-point empirical data. And just to go back to something Sasha said earlier in terms of empirical data and history, prioritization, the type of service field, was built into the Internet protocol from the beginning. And Christopher Yu has an excellent paper out on this that goes through that history, but that was built into the Internet protocol from the very beginning. They specifically noted in the engineering protocol that specified Internet protocol, in many networks, better performance for one of these parameters is coupled with worse performance on another. That was written into the engineering specification. In 1987, as consumers started coming on the Internet through online services, most networks prioritized telnet traffic over FTP traffic, so terminal services would continue to function with the huge increased demand for file transfers. And so this has been going on, this type of prioritization has been going on basically since the beginning, and we should continue to allow innovation inside networks and between networks.
Sasha, you were cited again by name, so we'll go to you
Oh,
next.
one other thing I wrote down that I forgot, sorry. I've got a Verizon pole in my backyard. I still own my house. Property can be encumbered. It doesn't mean that it's not property.
Right, it can be encumbered, that's exactly the point. Go ahead.
Encumbered by like net neutrality?
No, it can be encumbered by
But I am
speech
trying to get
regulation.
it, I am
It's
trying to get it
absolutely
moved, so Link, I don't know if you can talk to the local people.
Sasha, you got whiplash when he pointed out that prioritization was built into the cake from the very beginning. You seem to
Yeah.
disagree with that. Why do you disagree with that?
Well, it's not that I disagree. There's an 8-bit field built into TCP/IP protocol. It's useful for emergency communications within a network. It's been there since the beginning, as pointed out. It just really hasn't been implemented. Most importantly, that field isn't about prioritizing a particular service over another. It's for emergency communications. One of the priority levels is called flash override. It's like emergency communications to keep the network up. I don't think anyone's against that. No engineer is against that, no network scientist, but of course this is getting confounded, and I've heard a number of funny conflations. Intermodal competition, what is that? Well, it means that you have a national fiber network and a national DSL network and a national cable network. We're like the only country that decided, hey, let's build redundant networks at the national level instead of having meaningful competition on a particular network. That's been a failing of our communications. And the end result has been more expense, right? You have two overlapping networks, you're going to have higher sunk costs. But yeah, if you cite that and you don't look or know what that means, sure, number third looks good. It could be like, well, we were the third stupid country that decided to build a completely redundant national network. When I want numbers, I mean like the wireless competition report that's been coming out now for a decade. For the last, 5-10 years, has HHIs. These are measures of market concentration above 2,500. What that's showing is that we have a highly concentrated wireless network market. In essence, we have 4 national providers. You can all probably name those 4 national providers. And that's not meaningful competition. That's not meaningful choice. When people talk about equivalency of wireless and wireline, that's a joke.
How many would be meaningful?
Most of those providers have a data cap of 5 gigabytes or less. You know what that translates to? 1 HD movie, if you're lucky, a month. Is that meaningfully, functionally equivalent to a wireline network? Absolutely not. And to compare those things really is to perpetuate a piece of misinformation to all of you. According to the National Broadband Plan for the United States, 96% of people have 2 or fewer providers. You know how you get to meaningful competition in wireline, according to some? You take the same service, you put a different brand name on it. It's like buying the same car with a different hood ornament. That's not meaningful competition. And I'm talking about 96% of Americans, 2 or fewer providers, according to the FCC, according to our national broadband plan. So yeah, I think there's a yin-yang relationship between meaningful competition and government oversight. I'm not for government oversight of everything. I'm saying when there isn't enough choice, when you have outcomes that are worse, when you have incredibly high profit margins, when we're paying more for worse service in fewer locations than a growing list of other countries, yeah, that's a time when I want the government to step in and right what is clearly going wrong in a market sector.
Ryan, first of all, name 5 national wireless carriers. Second, don't you think that all-encompassing top-down regulations like net neutrality serve as an impediment to more competitors getting in? As the price of entry is raised by regulation.
You gotta get to audience questions, man.
I know, we're gonna be all right. Because I want to be fair, he didn't get to speak yet. When you raise the barrier of entry with regulation, the cost and the time spent dealing with it, you actually prevent more competitors from coming online. Do you agree with that assessment?
Yeah, to start with your last point, if what we want is for there to be, say, a fiber option offered by the incumbent in Silicon Valley, the way we go about that is not by reclassifying internet providers as Title II. That's the opposite approach that we take. We want to give broadband providers reasonable assurances that they can earn a return on their investment. The reason why Google chose Kansas City for its fiber is because the city relaxed a lot of conditions that it ordinarily imposes on entities seeking a video franchise. That's, again, my example earlier was with respect to Wilmington, Delaware, which imposed such onerous conditions that Verizon elected not to build Fios because it determined, presumably rationally, that it wasn't going to make a profit. So the deregulatory approach is what is going to encourage the kind of competition we want. Now, this doesn't mean we're going to have 5 choices of wireline broadband. That's not economically feasible, but at the same time, it doesn't mean we have to have 1. We can have 2 networks that exist side by side, and that is actually a good thing because it incentivizes the competing networks to make rational investment decisions in building out infrastructure. What Sasha pointed out was that it might make sense for us to have 1 national fiber network, and there are a lot of people who made this case that we just need 1 fiber network and let's compete over the network. The problem is that doesn't answer the question of who builds the network, who decides how much to invest, who decides which homes to serve. These are questions that, under that model, either are made by the government or made by a regulated monopoly. That's the old model. That's the model that didn't work. That's the model that we've abandoned. We have a model where companies compete. Now, that can mean 2 competitors, but you can't measure the performance of a market by the level of concentration. A market with 2 choices can work better than a market with 10 choices. By many respects, our broadband market works relatively well. Again, not as well as it could if we didn't have as many regulations and if there were less certainty. I think there are nationwide for wireless providers that have truly nationwide coverage, but most Americans, in fact, have many more than 4 choices if they're willing to deal with using some other carrier's network when they're in parts of the country that they might not visit often, which actually covers a very large number of Americans who aren't going across the country frequently.
All right, I'm now going to turn it over to audience questions for the last little bit of time. I'm going to please identify yourself so that someone can hear you and we'll start with that gentleman right there.
Dave Williams with the Taxpayers Protection Alliance. Boy, a lot to comment on here. You mentioned, Sasha, you mentioned that we pay $20 more versus the rest of the world when it comes to these services as consumers. I'd prefer paying $20 more as a consumer than a taxpayer. And when you have the FCC and the federal government spending tens of billions of dollars on government-owned networks, it's not really a choice as a taxpayer when the government wastes money on these systems like Chattanooga, which I'll talk a little bit in a second. As a consumer, you can go somewhere else. As a taxpayer, that somewhere else is another country. You talk about more and more bundling. My phone is AT&T, my cable is Comcast, and I have a Verizon MiFi. So I spread the love to 3 different companies, and I'm very happy with it. And they're happy with it, because 3 different companies get my business. But Chattanooga, Gigi, you mentioned that the local people get to decide on municipal broadband. Well, that was federal money. that was $500 million of stimulus money that went towards Chattanooga. They haven't delivered a gig. They promised to deliver a gig. It is a failed system. There's already 2 competitors in there doing a fantastic job. There's no need for that system. But they decide to spend upwards of $500 million to build a system that is not needed. And not only Tennessee and Chattanooga taxpayers, but federal taxpayers across the country are paying for a system they will never use. And it should be concerning to taxpayers and consumers because it establishes a really bad precedent. Phil, I think you mentioned Louisiana. That's state funded. An audit is due out this summer. Last year, they were what was it, $48,000 per subscriber that they were subsidizing down in Louisiana. These are failed networks at our cost, and I just think that the answer here is less regulation, not more. And you talk about, Sasha, about government oversight. This is government intervention. This is not government oversight. When the FCC is telling, this is intervention, saying what you have to do. And at the end of the day, it's all taxpayers that are affected by this. Thanks.
Sasha, you can go first.
You know, the local residents in Chattanooga and Lafayette love their networks. They're really happy about them. This notion of $500 million in government funding, I mean, that's wrong, but verifiably, factually inaccurate. The costs that are being talked about in terms of consumers, yeah, it's about $100. You know what speed they're getting? Way more than any of you. And they're getting free phone service, and they're getting huge numbers of cable channels, and they're getting broadband speeds that we can't get here in DC for even close to that price. So yeah, when you compare the top tier there at 100, 120 bucks for 100 megabit symmetric or in higher speeds, yeah, that seems a little expensive. Except to try to get a 100 meg symmetric line here in DC for anything even close to that amount, and then do the comparative analysis of pricing. I'm telling you, those 2 networks will look great. The reason why local people decided that they needed to invest in their local network is because they weren't being served adequately. You think a local municipality says, you know what, how about we become an ISP because everyone's giving us great service? No, they do so because they feel that they alone have the ability to provide the best service for their community.
And because
And
there are
more-
federal grants on offer.
And more communities are doing that.
Phil, you want to respond to that?
For those that say, you know, we shouldn't be using federal funding for these networks, I say, well, can I have all the subsidies we give to the telcos back, please?
Well, just to be clear, someone keeping their own money via tax break is not the same thing as writing someone a government check. Let's be clear on that.
It's not tax breaks. What's the universal service? What's universal service?
Well,
What's Lifeline? I
who's
mean,
pushing that?
Billions and billions of dollars.
I think we just found a point of agreement.
We can close the FCC, the UN, and the USF. This
why
is
don't you ask
fantastic.
AT&T if they want to give up their universal service funds?
Yeah, we disagree with them.
Yeah.
Or would
Yeah,
you?
but you guys don't
so
argue
you
that
think- right.
AT&T shouldn't exist
Right.
for accepting these funding, in the same way that you do with
Right.
Chattanooga and Lafayette shouldn't exist because they take advantage of federal funding that's available. I don't understand that dichotomy at all.
Well,
I don't think someone in-
AT&T would exist without those subsidies. We would like to end the
Really?
subsidies.
You don't think so? Then they're not quite as powerful as you make them out to be.
Anyone that knows the history of AT&T, anyone that's studied the last 100+ years of U.S. telecommunications policy knows that AT&T would not exist were not for investments by the federal government in their infrastructure.
Well, briefly, I think if we would probably have multiple AT&Ts. There were, as Adam Thier has pointed out, many companies actually offering competing telephone lines to the same homes prior to the 1914 Kingsbury Commitment. So we probably would have multiple networks today to a greater extent, overbuilders is what they're currently called, than we do. Briefly, the problem that I have with municipal broadband is not that the government's involved, as much as it is that it allows 50% plus one of the voting population in a city to build a service that is that is taxpayer funded by the minority of taxpayers. Now, government does that in a lot of respects, but it generally doesn't and shouldn't do that when it comes to the provision of private goods. That is, goods that people pay for because they want. A user fee-driven broadband network that puts taxpayers at zero risk, if the municipality wants to operate it in a way that, again, is purely funded through user fees with no government risk, that's not a problem. But as far as I know, there are very few networks where that can actually be described. Most of them either involve on taxpayer backing, or they use public funds that come from the general fund rather than solely through user fees, at least for the initial investment. That's not the way the government should invest.
So it's better for industry lobbyists to, give goodies to state legislators without the public voting. You know what, 51% or 50 plus 1%, that's called democracy. Love it or leave it, right? I mean, so the better system, and the system that unfortunately we've had for the last 10 years, is Comcast and AT&T and others going to state legislators and say, we really don't want these municipal broadband systems. Go pass a law. And with little public debate or little public notice, the law gets passed. Thank God that's starting to stop because municipalities are saying, holy moly, this could just drive economic growth in my area. I mean, you look at Chattanooga, you look at Lafayette, you look at Kansas City. What's going to happen is municipalities, particularly cities, industrial cities like Buffalo and Rochester and places along, in Ohio, they're going to say, oh my God, I want me some of this. Oh, but guess what, Pennsylvania? You have a law that prevents you from building municipal broadband systems. So I'm hoping, and I think we're going to start to see a turnaround in the next couple of years. So I like democracy better than smoky back rooms with state legislatures.
It'll certainly drive government growth. Phil, real quick.
I think we should welcome price discrimination for the most prodigious users who consume a disproportionate amount of bandwidth, and I think this is kind of where the industry has come around to, and I think it's very beneficial. A few years ago, they were calling these people bandwidth hogs, denigrating them, saying they needed to be blocked and capped and so on. Now the philosophy has largely changed to one of, we're very happy to provide this service. You want bonded DOCSIS or whatever, but you're going to pay for it, and I think that is a very positive development. It's a very positive response. The most prodigious users should be paying a lot more than everyone else. A government system that spreads those costs to everyone, that makes everyone pay more, so that the handful of people who are prodigious users don't face a more market-based price, I think is unfair.
I need to respond to that, because on the one hand, I think we agree. I know everyone's going to be stunned. Like, if we had true usage-based pricing, that might be interesting. But we're not talking about usage-based pricing. Right? We're talking about a baseline price, and if you're a big user, you pay more. But what if I'm a low-level user? Do I get to pay less? No, nobody ever talks about true usage-based pricing. It's always more. It's always about raising that average return per user. And what that means is you end up in a scenario whereby you're always taking a little bit more from me. And if I'm a low-level user, let's say I'm, what were we talking about before? Like going to France on vacation for the summer. Like, do I get to not pay my cable bill because I'm not using any services that month? No, that's not usage-based pricing.
I'm sorry. I just want to go back to the...
You are?
Oh, I'm sorry, Fred Campbell, CEI, with Ryan. On the municipal question, one thing that I haven't seen raised a lot is the jurisdictional boundaries that are at issue. And so there's a U.S. government report, and it's a little aged, but from 2005, that says about 40% of U.S. households are not served by municipal water because they're not within municipal boundaries. And so if a decision is made, we should fund this broadband through municipal networks, presumably they're not going to build outside their taxable boundaries. We go from having a relatively small lack of rural service to about 40% of the households, and then does that become a federal problem? I'm not saying I have the answers. I just think there are really interesting issues when you talk about municipal broadband, because if the municipalities, through use of their own rights of way that they don't charge for and the like, are actually able to drive out private enterprise. So I think when you talk about what the state legislature is looking at, I think one of the issues they have to figure out is how do I also serve the population that doesn't live within municipalities. You know, if you live in New York City, this probably isn't a big issue for you, but in a lot of states, I think that's a concern that they have to think about. And, you know, really hasn't been addressed a lot in this municipal broadband space.
And I'll just follow up with, you look at the VA, you look at Medicare, you look at Medicaid, the government's always looking to not pay for services. So once they drive out the private broadband, then does it become a game of the municipality saying, well, you're not in our municipality, you're not in our municipality?
But that's the presumption I don't agree with. Why is there a cause and effect between somebody builds a municipal broadband system and private enterprise dries up and goes away? They still have a huge advantage. They have a huge customer base, okay? They have good services. Is Time Warner Cable packing up their bags and pulling up their cable and leaving Kansas City?
You know that most of these municipal broadbands will be with smaller carriers, not large ones like Time Warner or Comcast.
Okay, what evidence do you have that where there are municipal, in the places that there are municipal systems, other services are pulling up their lines and leaving? It's just, the presumption is just wrong. Now, I think
Well, you have the RUS, $7.2 billion broadband stimulus, which
Okay, who's left?
Well, did drive several small
Really?
carriers out, yes.
Kansas, there's a gentleman in Kansas who had to.
Has filed a
close his
lawsuit.
shop.
Yeah.
And he filed a lawsuit.
Okay, you gave me one example.
Well, there's others.
Okay, well, I'm waiting for them. And there's could be a million other reasons why that person folded up their tent and left. Doesn't necessarily have to be because of the stimulus. But you gave me one example. Even if I take that as a true example, that to me does not.
That's one more than
does
current
not-
net neutrality violations.
What's that?
That's one more than current net neutrality violations.
Well, if the FCC would decide some of the petitions that are sitting in front of it. You know, you mentioned the FaceTime thing, which, by the way, this was the accusation that AT&T was blocking FaceTime, which was really squarely within the wireless net neutrality regulations. The FCC did not get involved. What happened was our groups negotiated with AT&T, and AT&T did the right thing. Okay, so this nonsense that the FCC is regulating the app stores, I don't know where that comes from, but you know, sometimes the great thing about the net neutrality rules is that AT&T had to come to the table and talk to us, right? Because we could threaten filing a complaint. But the fact of the matter is that the FCC had absolutely nothing to do with it at all.
And there is Minnesota and Connecticut too. I just remember there's two others where businesses were shut down because of the rural stimulus.
Again, you.
Well, let me give you a
I don't, you know,
counterexample.
you just say so. I could just, you know, I can make up stuff too. I have no idea what you're talking about. So.
Let me give you a counterexample drawn from telecommunications history. So in the 1900s, right after the turn of the century then, you had the growth of the home rural telephony movement. At one point in the United States, somewhere close to 40% of all phones were being provisioned by co-ops and folks. This is how you got to the rural farmers getting telephony. And this Kingsbury commitment, I think it was 1913, not 1914, but that commitment allowed for AT&T to discriminate in not interconnecting these home rural networks. So what did that lead to? Well, it led to the decimation of the home rural telephony movement. What it led is to higher and higher and higher prices, to the point that the government actually stepped in and put a price cap. I think it was 7.5% on AT&T, because it knew without that you'd have predatory pricing, you'd have ever-escalating costs. And eventually, what did that lead to? The government having to step in and break up AT&T in 1984. So when people propose to follow the same kind of process, I look to the history of the exact same company here in the United States. And I know that that history is one that harmed consumers and that we did not benefit from and that required more government intervention in the end. So what I can't figure out is why would we recreate the exact same market situations that already had a detrimental outcome prior? If the goal is actually less government intervention, I think we'd be on the same side. That the meaningful competition, maintaining a meaningfully competitive market, means there will be less government intervention over time.
Phil?
Well, I think that the whole history you just noted belies your argument for a single national fiber network that would just allow different brand names being sold. I mean, you're essentially saying we should not have the intermodal competition that we have now. We should have a single government-administered, run, and controlled networks with different resellers, which you previously suggested was not
Did anyone hear me saying any
attractive.
of that? Because I didn't say that.
We shouldn't have redundant national networks. We should have a single national network. This was your main pitch. That would recapitulate precisely the history that you talked about, getting rid of facilities-based competitors for a single network.
Government I can't understand how you're missing. Like, the
We've got
internet
tape.
is a network of networks that interoperate
That's correct.
and carry one another's traffic in a best effort.
Right.
I don't know where you're getting me calling for a national network out of that, because that's not what I'm saying at all.
You said that
I'm saying
you said
maintain the
facilities-based
network.
You
competition
did
is
say-
wasteful and redundant.
Yeah,
We
you
shouldn't
said there
have
were
the cable
redundant
network.
networks, there should
DOCSIS
only
was
be
a
one.
dead end, this kind of thing.
I said building a redundant network is wasteful. Yes.
So you're saying?
Thank you.
Yeah.
And so you
Network-
want to recapitulate precisely the history that you just said was a
Do
mistake.
you not understand the notion of a network of networks? Do you have multiple networks that are
Yeah.
all
Yes.
common?
They
You-
compete
you-
with
you
each
just-
other business-wise and interconnect for traffic. It's awful and redundant, you said.
I fear you don't understand how the internet works, because I'm not calling for one network.
I
think
fear
that
you don't
would be
understand how consistency works in argument. And I think it's pretty clear what
There-
you've said.
there is a
Now, you've
network-
said the two exact opposite things.
No, we didn't.
You've got to be kidding me here, right? Like, if I have a home network, and it connects to another network, and that network connects to another network, you have multiple networks. The reason why it's called the internet is because it's an internetworking.
Right?
Multiple networks that all can
Is
create...
facilities-based competition redundant and wasteful?
It can be, absolutely.
So you would like to have a single mode
No,
national network?
I'm not talking about a single network. I'm talking about multiple
No,
networks.
you would
that
like to
interconnect.
have, you would like to have multiple networks that interconnect in a
Yes.
single mode?
Called the internet. That's how you do understand.
Called
that's how-
fiber as opposed to cable?
Well, you're the one saying that. I'm saying the way
Well,
the
I'm just
internet
trying to
works-
understand the redundancy and the wastefulness that you've identified in our current system of intermodal competition, of which, of course, all interconnect.
To my house, if I had a water pipe, that'd be useful. If multiple people could provide me water or electricity, that would be useful. Building a second water pipe or a second electrical grid, that wouldn't make sense. And if you look at telecommunications history, we used to have multiple telephone systems going to one house. You had multiple phones, and that was really wasteful.
But that's what.
And if you look at,
doesn't that create competition?
electricity,
But
we had
you
not a
just-
national
You just said
standard.
consolidating them was a mistake, and we were just repeating that history. And we had those multiple telephony
No.
systems.
AT&T, I thought I was clear on this, but let me restate. AT&T refused to interconnect the home rule systems. It didn't create a network of networks. It destroyed these other networks in order to create a monopoly system. What I'm talking about is you need to maintain a network of networks. You need to maintain the internet and how it works. This isn't a call for one national network. It's not a call for one network that is owned or operated by any one entity. It's maintaining that diversity of ownership that is critical.
We are past our time. I want to
Only
conclude.
one wire to each home. You want only one wire to each home.
I think we've well past that. I'm saying it lowers costs. If you have lower sunk costs, it lowers costs for us, the consumer.
Well, that's a whole nother can of worms. We want to thank Gigi, Sohn, Ryan Radia, Phil Kerpen, Sasha Meinrath. I want to conclude by saying we do not know how the court's going to rule, obviously. We'd like to see various outcomes, depending upon who you talk to on this dais. We do know that I think we would all agree that in addition to closing the FCC, the UN, and the USF, we would also like to see a rewrite of the 96 and 94 Acts to update and actually reflect what's going on in the telecommunications world. Gigi, is that correct?
Well, look, I don't think a complete rewrite is possible. I do think there are some surgical cuts and surgical additions that could take place. I wish I could say that Congress had the courage and the ability to do something big. I don't think that's going to happen. We haven't, we've talked about the internet, we've talked about net neutrality, but we haven't talked about what's going on in the video market. where I think Congress could really make some changes. So, what I wish for and what can really happen, there's a guy who would be in charge of it, too. I think are really two different things. So I think we're pushing for surgical strikes as opposed to big rewrites. We're also trying to rewrite the Copyright Act, so we're very, very busy.
Yeah. You're always providing lawyers for things. We want to thank everybody for coming. We appreciate the attention, and we'll see you all again soon. Thank you very much.